Hello, everyone. Welcome to Conversations with Rudy Rivera. I'm really thrilled to have two special guests today. Oh, by the way, good morning or good evening, wherever you are. The topic for today is arbitration arbitrary or just a misunderstood process? That's really the question for today. And I have two really great guests. I have Svetlana Gitman and Nicholas Gowen. Svetlana works with AAA. They'll tell you their positions later. And Nicholas Gowen is a partner at the Burke Law Firm. Ladies first, Svetlana, please tell us a little bit about yourself, what you do, and then we'll go to Nick and we'll move forward.
Yeah, thanks, Rudy, and thanks so much for having me here today. So I am a vice president of the commercial division at the American Arbitration Association. I sit in our Chicago office, and part of my responsibilities is to help manage our roster of arbitrators, but I also do a lot of outreach and education about the AAA services, as well as administer the large complex commercial cases.
Thank you. Nicholas, how about you?
Oh, thank you, Rudy. Thanks for inviting me. Thank you, Svetlana. My name is Nick Gowen. I'm a partner at the law firm of Burke, Warren, McKay and Saratella in Chicago. I practice commercial litigation. I've also been a AAA arbitrator, handling complex commercial cases as well as consumer cases for about 3.5, 4 years now. I've been arbitrating and litigating and trying cases for about 20 years.
I got you beat, okay?
Only by a minute.
Only by age, because I've been a lawyer for 40 years. And so it's just one of those things where you look at your 16 and you wonder, oh my God, where did the time go? Thank you. And I'm Rudy Rivera, an international attorney. I manage litigation outside the US. I do a number of things, but mostly I have this channel because I just believe that we should have fun conversation on interesting topics with interesting people. So getting to it, as Como used to say, let's get to it, right? Arbitration is probably one of the most misunderstood areas of dispute resolution. People don't trust it. And so hence the topic is, why is arbitration arbitrary? But it really shouldn't be that way, right? Since you're with AAA, Svetlana, just tell us what the process of arbitration is. A number of our people are lawyers, but just for those who aren't, what was the purpose? Give us a little bit of the history.
Yeah, thank you. And even just to start to address kind of the big question, why is it a misunderstood process and why is it arbitrary? Arbitration is not meant to be arbitrary. It's actually a very calculated process. When parties are entering an agreement, they will make the decision, the conscious decision, that if any dispute arises, they don't want to go to court. They want to resolve the issue privately for a matter of reasons. Maybe they want to do it on an expedited basis. Maybe confidentiality is really important to them. And they will usually write that into their contract. But what sometimes unfortunately happens is they don't spend a lot of time thinking about that arbitration clause. They're entering into a contract. They're like, oh, all's good. We're friends. We're going to have a great working relationship. They never envision what can happen when things go wrong. And at that start, they never think about having a good arbitration clause. And so it's probably sometimes not detailed, doesn't have a provider, doesn't have an administrator, doesn't indicate the rules, doesn't talk about anything. And so when a conflict arises, it does become kind of arbitrary because they have nothing to guide them about the process. So they sort of have to make it up as they go along, or worse, if they can't agree on how to structure the arbitration process, they sometimes end up back in court, having the court get involved, which is totally not what they wanted to get out of this alternative dispute resolution process.
Well, I think that people do have it misunderstood, and I think it's misunderstood because they don't think through it. When I teach my international law class and we talk about arbitration clauses and dispute, I look at a business deal as the song from Meatloaf in Paradise by the Dashboard Light. You're going to swear your love to the end of time, and then now I'm praying for the end of time. And that's how a transaction happens. Everyone's in love. The business is going to go well. but nobody really starts to think, hey, what happens if it goes wrong? Because often the business leader doesn't want to know that. Nick, tell us your view on that.
Yeah, I think from my view, I look at it in two different ways. On the first hand, I think entering an agreement, so many people are looking at arbitration as just that midnight provision. It's that last thing they're throwing in right before the deal closes. Everybody's in love with one another. There's never going to be a divorce. And they're just not thinking about what happens when there inevitably is going to be conflict. And for me, it's a little bit easier to see that because my entire career has been getting into a dispute after the conflict has already arisen. Separately, though, I think there's another issue that people misunderstand in the arbitration process is that once arbitration begins, I have found that many parties consider arbitration to be a direct correlation to federal court litigation, and it's not. And I think there's a misunderstanding with the parties in that sense is they expect, okay, instead of me filing this case in federal court, I'm going to come to arbitration with the AAA. I'm going to have an arbitrator, but then we're going to run with the same rules, the same practices, the same procedures. And this is going to be, instead of a 2.5-year process, let's say, this is going to be an 18-month process. And I'm here to tell you, no, that's not what the purpose of arbitration is. It is a contractual relationship within the parties to determine how we're going to resolve a case on an expedited basis.
But how often you're an arbitrator, you're not, unless you've been in the past, a transactional attorney. How often could these mistakes be corrected by just thinking about it at the very beginning? You get it. I get it when it's done and you think, oh my God, who thought about this?
Right. I agree with that. I'm not a transactional lawyer. And I think you have to lay these processes and procedures out, as Svetlana stated, early on. When the agreement is being considered, when the agreement is being drafted, it is as significant and important to think about what's going to happen with the dispute resolution provision as it is what's going to happen with all the other reps and warranties that may be in an agreement.
And the business unit doesn't necessarily want to hear that. Okay.
Nobody wants to hear it until a guy like me or you get involved, Rudy.
And they say, oh my God. Well, some companies are trained to, when they run through an agreement, that they check with litigation counsel to basically give the blessing on the dispute resolution clause. Because I've seen somewhere where it's proposed that dispute be litigated in Prague. As much as I love Prague, it's a beautiful place to go, the St. George Bridge. I told the people, loser pays cost. And that's a lot. So you have to make it. And another times the arbitration clause itself is a deal breaker. It is a deal breaker. So what you're saying, Svetlana, with our prior conversations, is that people treat it like a federal court litigation. They want to do the same objections. They want to do the same type of discovery. So are you saying that in theory it should be exchange of documents and let the arbitrator decide, maybe some witnesses, some depositions, but not treated like a federal court litigation?
It should never be treated like federal court litigation. And what parties need to do is they have to read rules. Just like you wouldn't walk into a courtroom without reading like a judge's standing orders or something like that. You cannot choose an ADR process and administrator without reading and understanding their rules, because that's exactly what you need to expect. So for example, our rules, there is no rule that specifically says you have the authority to take depositions. In fact, some of our expedited procedures say you have no right to do depositions. So parties have to understand, and what I find a lot of time happens is that the attorney doesn't do a great job of explaining to their client what arbitration actually means. Like if your whole case is going to depend on, the testimony of third-party witnesses, you have to think about, is arbitration going to be a good tool for me? Because, arbitrators don't have the same kind of subpoena power or enforcement power that judges and courts do. So a lot of the time there's a disconnect between counsel and their client. You have to be comfortable with the process, and the process is explained in the rules. It has to be a good fit for the type of dispute that you have. And for disputes that are between parties that have ongoing business relationships, arbitration can be a really good dispute resolution mechanism if, again, you don't go overboard and treat it like federal court litigation.
Well, let me play devil's advocate here with you a second, because I've litigated a lot in the States. I've litigated a lot in foreign countries. So in line with arbitration, in civil law jurisdictions, there are no depositions. You present documents, there they are. You do have some witnesses. When you file your petition, you try your case. When you file your answer, you try your case. So in some ways, civil law litigation is, in a ways, like arbitration. Our system in the US is very, very, very cumbersome when it comes to, the documentation, the discovery, the depositions that can be used. So I find that people sometimes it's not that they don't necessarily trust the process, they may not trust the arbitrator. And vetting the arbitrator is a very difficult process in my mind. I've always said you cannot fix stupid. And as a trial lawyer, and Nick, comment on this too. I've won cases I should have lost cases I should have won. But in each case that I've lost, I knew why I lost it and why I won it. Very few times you're surprised. And sometimes what I've seen in arbitrations is, oh my God, how did they get to this decision? There's no logic to it. I think that's the fear people have. And so the selection process becomes extremely important.
Well, what's interesting about that is that same fear or concern exists in either state or federal court litigation. In Illinois, where Svetlana and I practice, there's a process called the substitution of judge. So it's a little bit different. If you land on a judge that you don't particularly want to have a case before, you have that one opportunity as a right to substitute that judge. Obviously, that doesn't exist in federal court. So that same risk exists, whether or not you're in arbitration or litigation. I think in arbitration, the concern is we don't know who this arbitrator is at all.
That's the issue.
And the only information we have about he or she is the same information that's kind of running around random people's law firm to say, oh, this person is good or this person is bad. What I suggest there is you've got to dig into the resumes. You've got to do more due diligence. And I don't believe parties are doing enough due diligence for the individuals who are being presented to them, either by the organizations or that they're finding on their own. I think what happens more frequently than not is people regurgitate names.
Well, Nick, I would take issue with you on one issue, and that is you can go to Westlaw and look at judges' decisions for the most part. You can see how they're ruling, how they're thinking. But until recently, you really had no way of doing that in arbitration. And the problem I have with people who are credentialed, some of them are earned and some of them are bought. And then it becomes a beauty contest. You're talking to somebody, he talks a good game, but he ends up maybe not being the right person for the job. And you call several other people. Now there is a company, in fact, I did an interview with them, Juice Mundi, where you can look at these arbitral awards and pick based on that. That's the uncertainty that people don't trust, I believe, is the selection process is not really a transparent process. It's a very hit and miss, right?
And Rudy, I just want to add in that it doesn't have to be that way. And first of all, we're very proud that we are working with Juice Mundi and publishing our international cases. So we're excited about that partnership and big shout out to them. But I mean, parties get to participate in the selection process in arbitration like they wouldn't in court. And they can tailor it. If both sides are in agreement about how they want it to look, they can tailor it. So they can go more in depth. They could interview the candidates. They can have us as the administrator provide more information for them, because that's allowed under our rules. So they can be involved, and they have that protection that, you know, they'll get more information than if they were just in court. I understand what you're saying about, you know, they can't see any decisions that this person has issued or anything like that. But I think the fear comes more from the part that arbitration is supposed to be final, right? There's no appeal process, which is wrong. The AAA does have an appellate process, and not a lot of people know about it, but you can write in an appellate process into your arbitration, and it doesn't sidetrack the spirit of arbitration, that it's supposed to be quicker, because in arbitration, the appellate process we've developed is completed in 3 months. So you're not in the appellate court for years like you would be in litigation. It's done in 3 months. You know, the briefing schedule is really quick. It's like 21, 21, 10. And so you have that protection that if that arbitrator got it wrong, it can go to a panel of 3 appellate arbitrators. So I think that's always really important to emphasize, that there are protections in arbitration against what you're talking about.
Well,
And I've sat
Yeah.
on an appellate panel before, and
Yeah.
I would agree with that. I mean, you're looking at it de novo. You're looking at this issue clean. And I think, if I recall correctly, we overturned the arbitrator, who was an experienced arbitrator.
That's the fear that people look at. You know, when you look at the famous Toys R Us litigation and they get to this outrageous number, you know, the appeals court, the court says, no, it doesn't matter how dumb it is, but, you know, it doesn't meet these criteria for setting it aside. And I get the fact that you don't want to have to litigate the validity of the arbitration in court, since the original purpose was not to go to court, right? So it brings us to our next topic, and that is, what is your end game? And that's something I think a number of people do not have. What is the end game? Any thoughts on that? We'll start with you, Nicholas, and then Svetlana.
Well, I think you have to look at it 2 different ways. Again, what's the end game as you're entering into the agreement when you're drafting the arbitration provision? And separately is, what's the end game once you've decided to pull the proverbial trigger and file the arbitration demand? Right? Are you really trying to stay together as a business unit or as a business relationship, or are you just completely trying to break apart? I think more frequently than not, you have business parties who are trying to stay together and trying to resolve a dispute, but what they're realizing is they can't resolve it on their own, or they can't resolve it with a mediator, so they're willing to take it to that next step, but they don't want to just destroy the relationship. So I think the end game has to be, same as litigation, is what's the business result? And what I advise clients, whether it's in litigation or in arbitration, is before you pull the trigger to go file a complaint, have an idea of what you want to do at the end of the day. Because if you don't know that, you're just spinning your wheels and you're paying legal fees.
Well, Nick, that's a very astute point, because the business unit wants to keep the relationship if they can. And of course, nobody wants their dirty laundry aired, so which is why it's often, you know, confidential, because arbitration is confidential, can be confidential. But where I think they don't have their end game in effect is, well, here's my suggestion is, rather than going straight into arbitration, go into a mandatory pre-litigation mediation. See if you can resolve it there. Anything that's used there will not be used in any kind of proceeding, so people can speak freely. No lawyers, just business to business. And have a mandatory time period that if it's not worked out by then you can go to arbitration. But at the initial beginning of the contract, the person has to reach out to you to say, Nick, if this goes wrong, how's it going to look? And that's the question that they don't ask. And I'm sure you see that in your arbitrations, that if people would have asked that question at the beginning, the process would flow much smoother. Svetlana, do you see the same thing too?
I see both of what you were talking about. So Rudy, we do see a lot of there's a mandatory mediation before you can even file for arbitration. And you'd be surprised how many times that either settles the matter or narrows it down. So it's not, 24 different claims being brought to arbitration, but it's like the main 4 that they need to figure out in arbitration. So that is such a good step. In fact, part of our commercial rules is that any case over $100,000, the parties have to opt out of mediation. So it's not mandatory that they have to engage in it, but they at least have to think about it, and somebody has to actively tell us, no, we're not interested, because we just believe in how valuable of a tool that can be. And to what Nick was saying, it is, as an administrator, it is very obvious to me when the parties have an ongoing business relationship. Their communication, their professionalism towards each other is definitely different than those parties that are like, we will never have a working relationship again. And that professionalism makes all the difference in getting the dispute resolved in a much quicker fashion, because they understand they don't want to break ties. They just have a dispute about this certain aspect and they want to keep working together. And in fact, we get a lot of post-dispute resolution submission. So they didn't have an arbitration clause. A dispute arose after they entered into a contract and they submit it to arbitration because they understand that, time is money a lot of the time. How fast they can get something resolved is really important.
Well, I think there's other things you need to think about. Okay. And I think there needs to be a meeting with contract counsel, and you as a litigator need to say, if we have to arbitrate, this is the effect of winning, this is the effect of losing, and more than likely this is the evidence we're going to have to need.
But Rudy, as an in-house counsel, how many of your business people are really going to understand what that means when you go to them and say, okay, everybody loves this deal today, but 5.5 years from now, if this unknown piece changes, are you prepared to marshal your resources to get ready for the dispute?
The answer is yes. Yes, I do that. In other words, many contracts that we have are contracts that can take 18 months to implement. And generally I know what the disputes are going to be when they come up. Okay. So when I'm meeting with contract lawyers, I say, these are this is probably the issue we're going to have. It's going to be failure to comply with the implementation process. So you need to keep track of that. Okay. And you need to constantly know who's who, what, when, and where, because here's what happens when you have a dispute. A company is not just one monolithic entity. You may have 30 people that you're going to have to go to. And you're going to have to keep asking and asking questions. But if you're in it at the beginning and you know the nature of the business, then when it comes time and the deal goes south, in other words, the deal is bad and you have to arbitrate, you're in a much better position as a litigator to shepherd the arbitration process too. But the other thing I talk to, these are some of the other issues I talk to them about. You can arbitrate, but where do you want to arbitrate if it's not virtual? Do you want to arbitrate in New York, or do you want to arbitrate in California, the most expensive places, or do you want to arbitrate somewhere in the Midwest?
Well, I think there's always a bias that seeps in, that people are thinking, well, if I don't pick a major market, then the arbitrator isn't sophisticated enough to handle the dispute. Or if I don't pick, or if it's an international case, if I don't pick a major global market, then the arbitrator won't understand what the topics are, or might be inherently biased against one party or the other.
And I think we should take chances on arbitrators who are not as well known, but who can be just as good. Because the ones who are well known tend to be very, very busy, and it becomes difficult to get on their calendar. But I'm sure AAA has a list of people who are great, and you can say, we want to litigate arbitrate in these particular markets, who do you have? And so that solves the problem, but it's at a cheaper price point. I mean, I look at all that kind of stuff. When they come to me with the agreement initially, I say, all right, where are we going to do it? What's the nature of the business? If something goes wrong, what do you think is going to go wrong and why? And then I review the agreement. I say, this looks fine to me. We can give in on this. No, we can't give in on that. And that goes in part of the negotiation.
And Rudy, you just described how the process is not arbitrary because you do all those things. Now, the problem is most people don't. They don't do those things. And then it can seem arbitrary, right? Because you have to make it up on the spot. You're going to argue about everything, including, where you're going to have it, how many days it's going to, you're going to argue about everything. So, I guess our global mission at the AAA is how do we educate more people about it? We have so much educational material. We've developed clausebuilder.org, which is a free tool that will actually help people draft their clauses. And day after day, I still see terrible clauses. So, it's how do we solve this issue?
Well, when you see those terrible clauses, eventually they go in front of the arbitrator to make the decision. And when the arbitrator has to make the decision, invariably one or the other party is going to think, well, this is just some arbitrary decision. And this is why I hate arbitration. It's like,
well, that's true, because arbitration is a creature of contract,
it's a creature of contract.
It can only decide what it's allowed to decide. It's also one of the bases to set aside an arbitral award if the arbitrator decides outside the contract or mismanifests disregard for the law, among a few others. I've seen, you're going to think this is stupid, but I've actually seen non-binding arbitration.
Which is crazy. That's just a waste.
Okay, Nick, you're going to be surprised to know
it worked apparently.
one day, not that's for my company, but one day I agreed to it, and here's why: because it was a big contract, very big, and that dispute was the deal breaker. But it goes to knowing your end game. So they were adamant about court trial. We were adamant about the arbitration. Nobody wanted to bend. The compromise was, because it's a big enough deal, that we will agree to non-binding arbitration. The position we took for my client was, if we got to spend all this money to go in front of an arbitrator, even though it's not binding, we're not going to go to court. And the other party said the same thing. We're not going to spend money to do this arbitration, go to court. It is a risk, okay? And we would tell people 100 times, don't do that, but never is forever. You can't say that, but it goes back to what is your end game? So we could have held our ground and missed a very lucrative contract. So sometimes it depends on the bargaining power of the parties when you put those provisions in there.
Well, it also depends on whether both parties understand that they want to, that they're willing to take that risk.
Exactly. And the flip side of that is people don't always understand the risk until it falls apart, right? So I think another part of the end game is really being conscious of what law applies in the area of international operation. So one of the benefits I see to an international arbitration is the fact that you can put a provision for cost. When you're litigating in Germany, you're litigating in some other place, cost could be significant. One case I had in San Luis Potosí, Mexico, they sued us for $20 million. Costs were $3 million because it was a percentage of what they asked for. So you've got somebody that says, I don't want arbitration, I hate it. I go, you realize if you lose, you're going to pay all their costs. We can fix that in arbitration. So that's also part of your end game, right? A civil jurisdiction, loser pays cost, unlike the states.
Well, Rudy, I've seen that more and more in domestic arbitration clauses too, that's included in the clause. It doesn't say the arbitrator must award them, but they can award them. So, as long as it doesn't, and, as long as the state law doesn't prohibit it. So we do see a lot of cases where the attorneys, that we have kind of what an interim award on liability, and then the winning side is allowed to submit their petitions for attorneys' fees and costs. And then the arbitrators decide whether to award them or not. So we see it more and more in the clauses now.
But there's a big difference though, because in the United States legally, you're only entitled to attorney fees if it's provided by statute, if it's in the contract. It's really the only time.
Right.
But in those
Yeah,
other
it's
jurisdictions,
different.
it's always allowed.
Right.
Always allowed.
Well,
You
it's the flip
huh?
side of the same coin.
Yeah,
You're negotiating a better opportunity through your arbitration agreement.
exactly. You're negotiating a better opportunity. You're not going to pay the cost. And some other provisions that I've actually included in some arbitration agreements. I mean, I sound like I hate arbitration. Believe it or not, I've had some experience with it, but
You're fighting against the tide here, Rudy.
I am fighting again. Listen, I know if I were in person, the two of you would be beating me up. That's why I'm glad we're virtual.
With kindness,
yeah.
kindness.
I hear it. I hear it a lot where, including family members,
Yeah,
who are lawyers, who are in-house counsel, and say this
I'll
is
say,
just
what? That arbitrator, he don't know anything. Let me tell you, that
arbitrator
dog
doesn't know
don't run.
anything. This is a sham process. I don't understand. No, let's slow this down a little bit. Let's talk this out.
Yes.
Like, this is the agreement that the parties entered into X number of years ago. And this is what you're working with now. And if you're saying, well, this arbitrator is so horrible, what steps did you take to select this individual?
Yeah,
before
exactly.
He got there.
And one bad arbitrator doesn't taint the whole process. That's that's the counter to that. But I think it's got its place. I think it's useful, it's valuable. I don't think it should be done all the time. And I think you got to be clear what we're talking about. What's your end game with it? And it's got to be strategic. And too often it's not. It's not, oh, let's just throw in an arbitration clause.
Right.
Oh, this is a contract that we found in the other contract. And they had, let's just use that one. Why not? And they don't think about the deal.
Svetlana raised a good point early on, and that was, if there is a potential dispute and it relies heavily on out-of-state parties, third parties, then that's something that the parties need to be considering leading up to that. And as an arbitrator, I advise, well, I shouldn't say I advise, but I inform the parties of this issue. It's like, look, my role as an arbitrator is fairly limited when it comes to issuing a third-party subpoena. Now, you come to me, presuming there's no objection, or I overrule objection from the other side, I'll issue the subpoena, but just let it be known, you have to enforce it. And there may be trouble to enforce it. And by the way, when you enforce it, you're going to have to enforce it. You're going to have to bring that person before me in my venue, because that's where I'm seated, to enforce that.
Well, and you can't enforce it. You can't issue sanctions. You can't issue a body attachment. You've got to go to court to get it. So one consideration would be is arbitrate where the witnesses are. And perhaps if there's too many witnesses that you're going to need to subpoena because some of them are hostile, let's say, then you may not want to arbitrate unless you find a way people could voluntarily produce them. This discussion is really great because I think what it's showing to people is this is complex. It's not easy. Yeah. And you need to give it a lot of thought. And, Svetlana, you're there to provide guidance. Nick, you're there to provide guidance. And that's, I guess, my role with this particular conversation is that what's the guidance in all of this? Something else that I've done is I've actually, when I've had an arbitration agreement, I've had the local law of that country apply as the governing law. And the reason for that is because in some countries, there is a provision for not enforcing an award. If they're not part of the New York Convention, or you've got some judge to say, you know what, I think that award's against public policy. But I said to my clients at the time, well, it's hard for a judge to argue that the laws of his country are against public policy. And if you feel comfortable about what your position is, then again, it's a risk, but it's something you need to consider.
Yeah, no, you bring up a good point. Enforcement, that's something that some parties don't think about. The example that I always give is cannabis disputes, illegality issues with certain states where it's not legalized for adult use, you have to think about things like that. And so, the information is out there. It's just like what Nick said, a lot of the time it's just the 11th hour provision. And people don't think about it. Like I said, we developed Clause Builder that will literally take you through all the steps. It will ask you to think about everything you could possibly imagine putting into an arbitration clause, down to like, do you need e-discovery? What kind of protocols do you want around e-discovery? Now, I'm not saying you need all of those things that we throw out at you, but it's not a bad idea to go through it and think about, well, do I need this? Is language going to be important? Is this going to be important? I mean, people don't think about language, but if you're in another country and you have to have a translator for 3 weeks, like, it's going to add to your cost, I promise you.
Oh, and trust me, translation is not a precise process. Interpretation is not a precise process. I mean, I've seen people lose money over one word in a contract. And you know which case I'm talking about, Svetlana. I mean,
Yes.
you see one word in a contract. Let me ask you this, moving on. And by the way, I'd encourage our people on Zoom, if they have any questions, I think I've enabled the chat, but feel free to ask questions to our guest. One of the things I want to cover is another criticism that has occurred is they don't seem to decide things, arbitrators do not seem to decide things piecemeal. You hear the whole thing, and where it could have been dismissed on some issue, arbitrators seem to be reluctant to make decisions within decisions. In other words, I'm just going to hear everything.
See, I disagree with that. I think that's, I think that is an assumption that parties have, the parties make, that that an arbitrator refuses to make a particular decision, is more willing to just split the baby.
No, I'm not talking about splitting the baby. I'm talking about making a preliminary decision. For example, like a statute of limitations is up. I'll take that up with all the evidence.
No, I'm making that point too. I'm making both points together.
Okay.
I think arbitrators are more willing to handle preliminary matters. I will agree. I think arbitrators are less likely to dismiss a matter early on unless it is clearly dispositive. But I think people will address significant issues early in a case to limit what the evidence may be, so they can get to the bigger issue. No different than what you'll see in federal court.
Those are some of the complaints I've heard in the arbitrations that I've had. We had to submit everything. There were no preliminary issues to be decided. Some preliminary issues were, well, do you really want to hear this evidence? Mr. Arbitrator, do you really want to hear this evidence? We don't think it's relevant. And even then, objecting for relevance, you're not in front of a jury, right? So hearsay, you have all kinds of stuff that you normally wouldn't have at a trial, which is okay, because the judge, who's a lawyer, most of the time a lawyer is going to see through all that.
Right, but wouldn't you have the same type of angst on a bench trial?
Oh yeah, all the time. Trust me. Yeah,
It's
all the time.
It's the same angst in a bench trial to say, well,
yeah,
why are we just bringing all this in at one time? Just handle it early on. And I think that's part of the thought process that the parties have to work through after, either right before or after they file their statement of claim, to say, what does this process really mean? And what it means is, we don't have 12 people in a box. This is a contracted process, is a process with hopefully a talented and skilled arbitrator on the other side, or excuse me, who's in the middle, and we've got qualified counsel on both sides, and we can make our arguments.
Yeah, but we as lawyers are trained, and I think we need to reset our mind to object to hearsay, object to improper foundation, object to everything that you would do in front of a jury. And in my mind, if we've got a good arbitrator, what do I need to lay the foundation for a document? If a witness says, well, my neighbor said this, you know, I could object, but the arbitrator knows it's hearsay, right? And probably not going to give it any weight. But people are still afraid to cut that loose. It's a habit that you've trained for 3 and 10 years of law school. You don't want to cut it loose.
I think
That's
that,
true.
good.
Yeah, I was just gonna say, you know, a lot of some other things that I see that kind of drive me crazy is, you know, provisions, arbitration clauses, which call for a panel of 3, and then each side gets to appoint one, and then the 2 appoint the chair. And the parties will take weeks, sometimes months, deciding on who their party appointed arbitrator is, and then deciding on who the chair is. And it's like, you know, they are serving as 3 neutrals at the end of the day. You have no pull over them. Like, I always want to shake the parties and remind them, like, you have no pull over them. They are neutrals, and none of them are going to risk their reputation, you know, to make it seem like, you know, they're likely to give your side a better award. But it is one of those mentalities that, you know, when I see that happening, I just think, like, this is not making it quicker, and this is not making it less of an expensive process because of all the time spent doing it.
Yeah, Nick, were you going to add something to that?
Yeah, I think this is probably a little more controversial,
Well, it's okay.
but I think parties worry themselves too much about who a particular arbitrator is versus what that individual's experience is and the strength and or weaknesses of their own case.
Yes.
Because at the end of the day, most of the time, the party with the best evidence is the one that's going to win. So, you know, trying to play games with who the arbitrator is, I think is a lawyerly game that we like to play, but I don't know how much impact it really has on the outcome of a case.
You basically end up being like a jury consultant, right? You're trying to put a crystal ball there to say, how is this person going to decide? Here, my issue with that, and I agree with you, but here's the one exception that I see, okay? As I said earlier, I know if I'm going to win a case, usually I know if I'm going to lose a case. But when you lose a case because you have no idea why you lost it, because there's no rhyme or reason to it, that's the part that makes me afraid when I'm choosing an arbitrator. I know what my defenses are. I know what the evidence is. But is this guy going to listen to the evidence? Is he going to respect the evidence? And quite honestly, in third world jurisdictions, I sometimes have to put in question, is this person honest? Is this person going to be honest? Are there other relationships there? I wouldn't necessarily have that question in the United States. And I know some of my friends from Latin America say, we're not all crazy, you know, but it is an issue. You know, it can be an issue in systems that are not, you know, well, for example, Mexico, they don't have a bar exam. You can't sanction a lawyer. You know, other places have a bar, but it's not good. That's a fear, I think, in international arbitration. So to your point, I agree wholeheartedly. You got the facts, you don't have the facts, right? And if you don't have the facts, you try to settle it. Right? What's that old cartoon? If you don't have the facts, no, if you don't have the law, pound the facts.
Yeah.
If you don't have the facts, pound the table. And if you don't have any of that, just jump out the window, right?
Yeah.
So what's your thought on that? Because that's a fear for a number of people I've seen.
I think
I've talked to internationally.
Well, I can't speak to internationally. I mean, the international arbitrations I've conducted have all been in the States. So they've been involving non-US parties, but the arbitration venue was in the United States. But what I would say is, for the most part, as it relates to in the US, I think it's an unfounded fear.
Yes, I would agree with you. I would agree with you on that.
And I would also stretch a little bit and say, if you're concerned, if a party is concerned about whether or not an arbitrator in a non-US jurisdiction is corrupt, then that party should also be concerned whether the judicial system is corrupt. Because it
is, but people still choose to do business there. Okay.
Right. But if that is true, then the concern is not with arbitration. The concern is with the honesty of the judiciary and the judicial system.
Well, let's not use honesty, because I have several lawyers from Latin America. Let's just say the transparency.
Okay.
Of the situation, because I know I'm going to get calls from some of them saying, "What'd you say?"
Well, I'm not casting aspersions on anyone. I'm saying, but if someone is concerned about an arbitrator in a non-US jurisdiction, not honest, or is on the take, or is corrupt, or whatever term you want to use, if that person is also a member of the bar, presumably that person is working within a system that is also corrupt. So I think the concern about the arbitration being untoward is overblown, because it seems like the entire system is questionable.
Yeah, that's a very good point. That's a pretty good response to that. I find that in the developing countries I've worked in, I generally expect to lose in the first instance and win at the appeal level, where the courts are more sophisticated. But it's still that's more I think my fear in the development, and I'm not just talking about Latin America and other places, you know, in Southeast Asia, maybe Eastern Europe. You just never know, you know. And part of the problem for us as lawyers is, if you're not a practicing lawyer, say in Romania, and you can pretty much pick an arbitrator in the States, and you speak the same language. And I'm not talking about the language. I mean, you speak the same legal language. But when you go into a jurisdiction where you don't, then you're kind of at their mercy. And that's the fear factor. Okay. I think that's what adds to the fear factor. And I want to go on record as saying, I'm not saying everyone is corrupt. I'm just saying, is there issues with the system? It can be, you know, sometimes there are issues with transparency, but for the most part, you know, people still go into those countries because they'll make a lot of money. And at the end of the day, they're willing to put up with the risk. Now, let me ask you, again, let me ask if anyone in the audience has any questions, but what do you think, and I'll ask you, Svetlana, first, and then Nick, what is the biggest mistake you see? I mean, if you can single one out, and you can't picking non-binding arbitration, because I already did that. So.
No, my mind has changed. You gave a good example of when it can work. So, you know, I'm okay with that. That's what the parties want to do. Let's do it. The biggest mistake I see is, and I mentioned earlier, people not reading the rules, not knowing how to, like, not understanding the purpose of the rules. And rather than reaching out to a case manager or asking the arbitrator, they just do what they've done in litigation. Like, for example, under our commercial rules, you don't just file dispositive motions. You actually have to ask for permission. The goal being that you're not going to file this motion if you don't have a high likelihood of prevailing on it, or at least streamlining the issues. You're not going to waste time briefing back and forth. Like, that takes up time. Arbitration is supposed to be expedient. Well, some parties will just totally disregard what's in the scheduling order and just file a dispositive motion. And you know, the way I see it is like, there's no way the arbitrator is going to be okay with it. And they have just spent so much of their attorney's time, or, you know, the attorney has spent so much time on that, that's adding to those costs. I'm a very cost conscious person. So when I see parties not reading the rules or the scheduling order, I just see, like, you know, those, like the cha-ching, the money sign, and like more money spent, which again defeats the whole purpose of arbitration to me. So if I could just urge people to do one thing, it's please read the rules and the orders.
Nick, how about you?
for me, it's a play on that, and that is people who enter arbitration thinking that it is similar to federal or state court litigation, whether they believe the timelines are going to be the same, whether or not they believe that the oral and written discovery is going to be the same, whether they think the motion practice is going to be the same. And I tell clients when I'm an advocate, and more often than not, I tell litigants when I'm an arbitrator, this is not litigation. And I'm not going to allow this to turn into a federal court matter. So you don't need, your parties agreed to arbitrate. So we're not going to have a situation where there's just going to be, expansive, never-ending discovery.
Rudy, I think if I could just say, I think what I think is the root of the problem is that we don't educate law students about alternative dispute resolution the way we should. When I was in law school, there was maybe one class on mediation or arbitration. And you don't come out of law school understanding the alternative processes to litigation. And it's we have to plant that seed younger so that students, when they're entering the field, know the difference, not just assuming that everything is litigation and arbitration is just a private version of litigation.
Well, they used to call it in my day when I was a baby lawyer, rent-a-judge. They used to call it rent-a-judge. We have a question that says comprehensive early case management orders with a calendar are an important tool to be used.
Absolutely. I think you have to schedule, you have to have an early schedule. It has to be reasonable. It needs to be clear, and the parties need to stick to it.
And I think the arbitrator plays a really strong role too. The arbitrator has to send a message that I know you might agree that you want more time, but unless you give me a great reason and a short extension of time, don't just think I'm going to agree to whatever you want me to do. Because that's a mistake I see sometimes. And sometimes I have to remind the arbitrators hey, I'm not telling you what to do, but did they even give a reason for why they need the extension?
I agree with you. I think the issue with that is that the arbitrator needs to be firm in enforcing the contract under which he's going to arbitrate. So it's for the arbitrator to allow the parties to agree to extensions. And once you're selected, the contract's in place. I think a strong arbitrator will hold them to the fire and just say, no, we got these deadlines, that's the way I look at it. Well, I'm going to tell you my pet peeve. Okay.
Let's hear it.
Now, and it really isn't so much with arbitration as it is that I'm a big believer that as lawyers, we're storytellers. And you want to tell a simple story. When you get into an arbitration, a judge tried litigation or jury trial, what is the story? And then you back it up with the explanation. But if you don't have the story, if you don't have that little piece of evidence, what does this case consist of in 2 or 3 sentences? People don't do that. As a result, you get some confused, multiple evidence, multiple issues. But at the end, you got to stick to your story. And that's my pet peeve. I see things that are so complicated. And I'm saying, what are you really trying to say with this? That's my pet peeve. And it's not just with arbitration, it's with litigation, anything. My old law partner, when I was a baby lawyer, said to me, the true test of being a great lawyer is taking something complicated and making it simple. Because back then it was a jury, right? Now it's a jury, arbitrator, you name it, administrative law judge. There are a lot more sources, but always make your story simple, concise, and build on that story with the evidence.
And just to even go further on that, Rudy, I'm always shocked at, when parties are submitting things, how they don't put more effort to organize them nicely. that it's easy, that you're like literally holding the arbitrator's hand and getting them to the conclusion that you want. You just kind of dump everything. And it's kind of surprising to me because sometimes the scheduling order the arbitrator enters will tell them like, this is how you need to label all the exhibits for me. And they just like don't do that. And it's always mind-boggling. And Nick, I'm sure you can speak from the arbitrator point of view, how helpful that really is.
It is. I actually recently was an advocate in an arbitration that I won, in part because the arbitrator was so unhappy with the other side not actually making clear, cogent arguments. And the other side said, the information is there, it's in the documents. And the arbitrator was like, it's not my job to go hunt for this. It is your job to present it to me. Now,
Exactly.
I would say that we had the better argument, both legally and factually anyway, and that's
Oh,
not the reason we
of
won.
course. Of course, you got the better argument.
When the arbitrator made clear, and this was a retired federal judge, made clear, it's like, look, other side, these are the errors that you made. You need to walk me through what your arguments are, and you failed to do that.
I get what you're saying, because you want to do the work for the judge. You don't want them to do the work for the judge. If you do the work for the judge, your arguments are clear, you're concise, and you say, Judge, this is the order I want. Right? You give it to him. You make it easy for him. But yeah, it's crazy. I'm a big believer that you win cases one of two ways. One, on the law, and two, you out procedure your other side because they don't follow the rules, they don't understand rules, and you beat them up on the procedure. Those are two ways to win a case.
Well, you have
of
to have a
course, there's
strategy
always
before going in.
your charm. There's always your charm too, right?
Well, you're not charming an arbitrator, maybe a jury.
Yeah, charm the
Good
jury.
point. Good
Yeah,
point.
yeah. You don't have the same theatrics in an arbitration that you would have with a jury trial.
It is unfortunate. You're sitting around a conference table. It's like, I need a little bit more action.
But people do try, and sometimes I've kind of been like, why are you doing this? We've had hearings where they wanted to bring in these large monitors, to have these huge TV monitors, one behind the panel, so that when they're giving their opening argument, they're not looking down, but they're looking up at the panel. And I was just like, again, those money signs kept ringing in my ears. And I was like, why are you doing this? The panel's not going to care if you look at your notes when you're giving the opening argument. And so to me, that's a benefit of arbitration, why it could not be as expensive, because you don't have to kind of put that show on for these people. But I'm telling you, people forget. They come in with these monitors and the state-of-the-art stuff, and I'm just like, no, don't spend money on that.
Yeah, they can go overboard. I miss trying jury cases because it was fun doing the theatrics. Okay. It was fun doing the theatrics. I tried a lot of criminal defense work. I tried some civil cases, but it was always fun getting in front of the jury and doing the theater. Especially, when your client's a drug dealer and you're trying to paint him in the best light possible, and it's hard to do in front of a jury.
Probably not the best case for arbitration.
A drug dealer? Well, you never know. Well, if they argue that they split the baby, the drug dealer may want an arbitrator, right? So, well, thank you everyone for signing. I'm going to sign off of LinkedIn now. I want to thank everybody for coming on. Let me stop the live stream. And don't forget, you are watching Conversations with Rudy Rivera.